everyone. Thank you for joining us today. I am Hannah Shea, World Law Group's Manager for Communications and Network Development. And this is our second webinar in our trade series, this one being on export control. Last month, we focused on sanctions. And before I hand it over to our panel, I just wanted to note that you all should be muted upon arrival, and I'd like you to stay that way until the questions at the end. If you have questions throughout or at the end, please drop those into the chat, or you can use the raise hand feature to ask a question. This will be recorded and will be available on our website probably next week after that you can share with colleagues. So with that, I'm going to go ahead and hand it over to Vera, who is one of the co-chairs for the International Trade Group.
Thank you, Hannah. Good morning, good afternoon, good evening. On behalf of the International Trade Committee of the World Law Group, I'd like to thank you for attending our webinar, Exports Controls, which is the second webinar about the broader subjects of sanctions. The first one was Sanctions, the Evolving World We Are In, that took place in March. Sanctions, generally speaking, are central aspects of the international arena, mainly in 2022. And controlling the flow of goods, services, and resources in general is guiding the relationship among the countries globally. We have never seen this before. For this reason, it's important to follow the legal framework that is shaping the world we are in today, and hope we can assist you in this not easy task. In other words, we plan more webinars in this year. As you will see, export controls is part of this new reality. In this webinar, we will provide you with an overview of the export controls rules imposed by the US, Australia, and the European Union. My name is Vera Canas, partner in charge of the International Trade Practice Group at Tosini Freire, Brazil, and I will moderate this webinar. Let me introduce you my colleagues. David Morfesi will speak about the legal framework and experience of Australia. David is the director of Minter Ellison in International Trade Group in Australia. He specializes in WTO law, free trade agreements, bilateral investment treaties, anti-bribery and corruption, sanctions, export controls, trade remedies, customs matters, and regulatory matters affecting trade in goods and services. Michael Brugman will speak about export controls in the European Union. Michael is partner at Taylor Wessing, Germany. He advises companies on the EU legal framework for imports, trade remedies, EU free trade agreements, and the EU anti-dumping regime. He also focused on advising exporting companies in terms of embargoes and trade restrictions in the EU dual-use regulation. Moni Sitkowski, partner at Faegre Drinker, Chicago, will speak about the US export control system. Molly assists with export controls and compliance matters, including advising on export screening and classification, and filing license classification requests and voluntary disclosures with the US Department of Commerce, Bureau of Industry and Security, and the US Department of State's Directorate of Defense Trade Controls. She advises US headquartered multinationals as well as foreign-based multinationals on compliance with the US sanctions laws and extraterritorial reach of the US export controls. Before we dive into our panel discussion, let me quickly share what export controls are, how they're used, how they are different from sanctions. In fact, it's part of the sanctions regimes. So let's first start with a refresher on sanctions from our last webinar. Well, international sanctions are actions, generally speaking, taken by countries against other countries for political reasons, then they can be unilateral or multilateral. Multilaterally, international sanctions are normally imposed by the United Nations, okay? The sanctions can be diplomatic, for example, asking diplomats from getting out of a country or asking questions to diplomats, sports, like not going to the Olympic Games, military, of course, like wars or military interventions, and economic ones. The economic sanctions are actions or restrictions normally related to economic or trade aspects, and they in general can be trade bans, embargoes, or financial restrictions, such as, for example, the withdrawal of the SWIFT system of certain banks. Talking about the coverage of sanctions, they can cover a whole country, like, for example, Belarus, or a region, for example, Crimea. They can cover, they can target a company or an entity. It can be an association or an ONG, for example. They can target individuals, certain, I don't know, oligarchs or certain people in Iran or in Cuba, for example. And they can target also certain products or sectors, a specific product like luxury goods, or they can target a whole sector like oil and gas. Now let's talk a little bit about exports controls. Regarding the exports controls framework, globally speaking, and my colleagues are going to speak about the specificities of each country or region. But globally speaking, we make reference to the Wassenaar arrangement on exports controls for conventional arms and dual-use goods and technologies. It is a multilateral exports controls regime. It's voluntary, and it with 42 participating states, and it was established in 1996. For you to understand, Australia, New Zealand, the US, UK, and the EU are part of this arrangement. Brazil is not part of this arrangement. I don't know why, I can check this later for you, but Brazil is not part of this arrangement, although we incorporate some of the concepts in our exports controls legislation. It focused on the exchange of information on transfer of conventional weapons and dual-use goods and technologies, and it produces the base classification tables for both dual-use and munition list items. The concept of dual-use is based on common sense. Are those goods that can be used in weapons, and they can have another use that is not for weapons. But because of this possibility of being applied for weapons, it is also subject to this regime. Okay, for example of dual use are, I don't know, plutonium or sometimes some chemical items that can be used for weapons, that they can have another use, like industrial use. And an example also of non-dual use that can also be subject to exports controls, and it's new, and my colleagues are going to speak about this, we can mention, for example, wines or luxury goods. They can never be used for weapons, but they can also be subject to export controls. The participating states, they seek through their national policies to ensure that transfers of these items do not contribute to the development or enhancement of military capabilities, which undermine the goals of this arrangement, and they are not diverted to support such capabilities. It focused primarily on the transparency of national export controls regimes, and it was an arrangement that does not involve any veto power, for example, to individual members, but gives the freedom to this to every country to establish its own export controls regime. But there is a secretariat for administrating this agreement that is located in Vienna. Every 6 months, the member countries exchange information on deliveries of conventional arms to non-Wassenaar members that fall under 8 broader weapons categories. The list of restriction technology classification items is in 2 parts. The list of dual-use goods and technologies, that is also known as basic list, and the munitions list. The basic list has 2 nested subsections, sensitive and very sensitive. The items are not specifically enumerated in the dual-use list, the munition list, or other exports controls regulations. And for example, the US Nuclear Regulatory Commission regulations are referred to as non-dual use, as I mentioned, for example, luxury goods in the EU and ER 99 in the US. Whether or not something requires a license from any country generally depends on its classification on the dual list and its end destination. Now that we've got over what export controls are, let's dive into the specifics on them. The dual use and the non-dual use items, licensing requirements, and what end users have different requirements. Let's start with you, David. And before you jump on the specifics on this Australia and New Zealand, perhaps you can define those terms for us: dual use, non-dual use, and end users. Thank you.
Thank you, Vera. I probably don't have to say anything after that introduction. You've pretty well covered the field. But thank you for that. And thank you, everyone, for joining us tonight, for spending the time with us. We very much appreciate having you. Here in Australia, the Defense Trade Controls Act is the main legislative instrument implementing export controls. And under that, we have in Australia the DSGL, the Defense and Strategic Goods List. This is the Australian equivalent of the list under Wassenaar. And it has the two parts. Those that are military spec, which is the munitions list, part 1, and part 2 is the dual use list. Vera asked me to discuss that a little bit, and let's not forget military munitions. This is defense export controls, so it starts with that. But then it moves into those goods that are dual use, which have a potential military application, but a potential non-military application as well, which is why this control has sort of differing levels, as it were. There's a non-military application, which is legitimate. And while it is important to control these technologies these goods moving from place to place, it isn't necessary to stop them moving from place to place because they have, again, legitimate use that's non-military. So that part 2 of the list here in Australia are those dual use goods. An example I always like to use, and I'm not actually sure it's 100% accurate, but it makes the point. Have you ever been to the beach and seen an old man wearing a hat, waving a big beeping thing over the beach, looking for rings and bottle caps and anything else he can find with a metal detector? Well, if you paint it dark green, it's also a minesweeper. And they use them in combat zones. It has legitimate non-military use, but it's effectively the same technology as you would use to detect landmines in a war zone. And thus, exporting that, you want to know where it's going and who it's going to. End users and end uses. Who is it going to and why? If it's going to the little old man in a hat, you're not too worried about it being in the wrong hands or being somewhere where you don't want it to be. But if you're sending it to the military, you have a pretty good idea of where they're going to use it. So end users and end use. It's about context. It's about the situation at hand. So every situation and every export needs to be judged separately because you need to know, particularly with a dual use item, who is the end user and what's the end use as well. Going quickly through regulation here, I won't go through all of it, but second from the bottom, is interesting and important here in Australia. The Customs Act, Section 112BA, military end use provisions. Sounds military, sounds like we're talking about part one of the list, which sounds like we're talking about munitions. In fact, this is the section that is sort of a national security catch-all. It controls non-dual use items. If they may contribute to a military end use that would prejudice Australia's security, defense, or international relations. In other words, they get to choose, they get to decide on a case-by-case basis if things that are not on the DSGL, not on the defense and strategic goods lists, still can be controlled if there's a national, if it's in the national interest to do so. So here's a case where, and the exception in Australia, where even non-dual use items can be stopped. And consider the argument. May contribute to a military end use. All right. Sounds like you might not be able to stop everything under that. But it's a very broad exception. Might prejudice Australia's international relations. So I believe it's the foreign minister is Lavrov, and he is a sanctioned individual. Anything going to him, to his benefit or his comfort, could be seen as furthering whatever efforts Russia is taking right now that Australia wants to counter. Accordingly, if you send him a pallet or a consignment of wine or toilet paper or surfboards or anything from Australia, anything that we're known for here, it might be seen, and there is a colorable argument that there is an end use that furthers what's going on in Russia right now, or with Russia right now. It's a very broad exception. And again, all of these are taken on a case-by-case basis. I mention this specifically when we're talking about Russia because, believe it or not, in normal situations, not times of war, this military end use provision is brought up very frequently here. And it's not even when you're shipping or exporting goods to someplace that you might consider interesting or dangerous. The fact is that the Office of Defense Export Controls here will often remind an exporter, especially an exporter of dual use goods, but they don't have to be dual use goods, that they should apply for a permit so that the office can clear whatever it is being exported for that exception, which is national interest. Next slide, please. But there are specific offenses here in Australia for violating export control rules without an export control permit. If you supply DSGL technology, or even if you just publish technology that's on part one of that list, that's the munitions list, if you make that public. And brokering, an important aspect of this, it's arranging supplies that are on that DSGL list. So imagine someone in Australia arranges for somebody in South Korea to send DSGL controlled goods to Russia. They're not sending them themselves, and they're not even sending them from Australia, but in Australia, they're arranging for the goods to be sent from one place to another. And that's brokering here in Australia. Importantly, Section 25A of the Act, how is it prejudicial to the security, defense, or international relations of Australia? And it's funny because I put that little parenthetical sick because it's actually not really good English. There's a mistake in the title, but that's in the Act, so fair enough. But in this case, this is another area where Section 25A is used, and it tells you that, again, this is a case-by-case decision on behalf of the office, on behalf of the delegates of the minister. Something that may normally be deemed to be uncontrolled can suddenly become controlled. Software is quite often a controlled technology. It can be a controlled technology. And there are exemptions for that when it's publicly available, widely distributed. But it's still software, which is in and of itself technically controllable. But if you're sending it to Russia today, even if it's publicly available, is that something they might see as prejudicial to the security, defense, or international relations of Australia? Yesterday, that may not have been something they wanted to control or cared to control. Today, it might be. Section 25A, it's important to know. Next slide. Now, one of the reasons it's important to talk about export controls is the interaction between export controls and sanctions. There's prohibition on directly or indirectly supplying, selling, or transferring to Russia any arms or related material. While each case is, again, considered individually, goods on the DSGL very likely to be considered arms or related material. They're on the Defense Export Controls list. Therefore, it's pretty good evidence, and it's right in the sanctions policy that is considered quite likely to be the part of that sanctioned material. It's all about context and the end user and the end use when it comes to goods on the DSGL, and also goods that aren't, such as prohibitions on non-dual use goods under sanctions, luxury goods. I think all of the countries that have the major countries that we're talking about, the EU has, the US has, and Australia has, they've all banned the export of luxury goods to Russia. My favorite is the fact that Australia has banned the export of caviar to Russia. There's an expression, an English expression, carrying coal to Newcastle, because Newcastle is where they mine the coal. You don't bring coals to Newcastle. We're apparently exporting caviar to Russia, but we're not doing it now. But importantly, what we're also not exporting, and we're doing it down to $0 value, any value, we're not exporting wine to Russia. That's a huge cultural thing here and a very important symbolic export of Australia, and we're not sending any of it. That's a message. That's saying something if it's coming from Australia. Next, please, because I'm going to give my colleagues a chance to keep talking. I mentioned national interest. When it comes to sanctions, again, depends on the circumstances. With Russia right now, there's a lot of exports that would be judged to be against the national interest. You want to look at the broader objectives of the particular sanctions scheme and whether a sanctions permit would be, if you want to try to export to Russia, would you be successful? I'm very doubtful about a lot of that, but it depends on the circumstances. Whether the activity is in the interest or would be advantageous to Australia as a whole, economic, security, foreign policy. I didn't put down environmental. That's an important one. Think about that. Any effect on Australia's international reputation or standing or external relations. What does Australia and Russia have in common? Mining and extractive industries. Those are other than agriculture, that's the big one. And what we do well here in Australia, we're doing more and more of, are things that make those industries more environmentally friendly, and we export that technology. And so it's hard to say that the oil and gas industry is environmentally friendly, but there are ways to extract it that release less carbon. And we're good at that. Should we be able to export that to Russia? Because they bring a lot of that stuff up out of the ground too, and it's better for everybody if there's less emissions. That's the kind of question that you'd ask and say, is it advantageous or is it actually benefiting the Russian oil and gas industry? And so that would be a question, and that's the kind of thing that you consider. But the dot points above, where else would they seem relevant? That military end-use provisions in export controls for non-dual-use goods. If it may contribute to a military end use that would prejudice Australia's security, defense, and international relations, the same sort of national interest test. That's what they're looking at. So these things are starting to be used in a way that's interchangeable. That where you're using sanctions in a way that would indicate more of a export controls function. But then sometimes now export controls have been used in certain jurisdictions almost like sanctions. Whereas not just controlling the technology, but why you're sending it and who you're sending it to, for human rights violations and acts of war. So yeah, the line between them is being blurred a bit, and it's sometimes hard to keep track of what the objective of each of the regimes actually is and how they're different from one another. I think that's it for me. Is there any, is that it, or do I have one more behind that?
That's it for you.
That's it for me. Good, because I've talked enough.
Thank you, David. Thank you very much. This interaction between export controls and sanctions that you mentioned is very, very interesting. It deserves another webinar, maybe. Let's talk about it later. But now, Michael, I'd like to hear from you about the export controls in the European Union. Please go ahead.
Yeah, thank you very much, Vera, and welcome to all participants from my end. I would like to give you a basic overview on the EU export control regime and in particular its relation to the sanctions, especially with a view to the new Russia sanctions. I think with a view to the time frame, I will limit it to really an overview, because as Vera said, it would fill another webinar to go into details and to cover every detail. So I would stick to really the basics and the basic principles, as Vera did for the Wassenaar arrangement and also David for the Australian regime. First of all, it's important to know and to keep in mind that the EU has a unique export control law for all member states. So as you know, the EU is a unique customs territory covering all 26 member states. And the export control law is basically governed by EU law for all member states. That applies to the, at least to the common dual use control. There are additional and specific provisions by member states for arms control and exports of arms and weapons. But when it comes to regular dual use items, which are based on the Wassenaar List 1 and Annex 1 to the EU dual use regulation, then this is governed by such EU dual use regulation, which is directly applicable in all EU member states and is directly binding law in the member states. So the material law is governed on an EU level, and the administration and also the legal consequences, such as fines and penalties, they are left to the member states. But in general, the system is unique at EU level, and you have a unique regime at EU level. So the main legal source and basis is the so-called EU dual use regulation, which was revised in September 21, and which is now named number 821 of 2001. So this is the central legal source for the whole EU export control law. And as I said in the beginning, there are additional provisions of the member states for exports of weapons, war weapons control. So sometimes when it comes to weapons, you need two authorizations, one under the EU regime, under the export, under the dual use regulation, and then in addition under the war weapons control list of the competent member state. The dual use regulation contains a common list of dual use items, that is Annex 1, and it is based on the general Wassenaar list that Vera mentioned in the beginning. In principle, in the EU, the export of every item is free, so you don't need an export authorization. You only need an export authorization when this item is controlled by the dual use list, i.e. by Annex 1 of the dual use regulation, or if it is covered by the so-called catch-all provision, which is Article 4 of the regulation, and which refers also to the military end use that David explained, but under the EU system also, and that's an additional requirement, that the country of the receiving country is an embargo country. So this can in particular be relevant for exports to China. And because, you know, this is formally still an embargo country. And there are, and that are in particular then the provisions for non-listed items, so the catch-all provision. If the item is controlled, it is subject to an authorization requirement, and the competent authorities are in the member states of the EU. So for instance, in Germany, it's the Federal Office for Export Control, the so-called BAFA. And depending on the receiving country, you need to apply for an individual authorization, or you can use a so-called general authorization. So for instance, for the for important exporting countries like the US, there's a general authorization, EU 001. And in that case, you only need to register with the Federal Office for Export Control. And that would be sufficient then in that case. So if you have an item which is controlled by Annex 1 and you want to export it to the US, you need to register for this general authorization, and then you can export it, and you need to, of course, you need to meet some formalities, but then you can export it. Otherwise, if you have not this general authorization, you need to apply for an individual authorization, and then you can only export once the authorization is in place. Like the Australian system, there are of course fines and penalties in case of a breach of these dual use provisions, which are of course also significantly in the EU. Yeah, the regulation, and that's important, is directly applicable throughout the EU. And there are provisions under national law of the member states, for instance, in Germany, in the Außenwirtschaftsgesetz, which is the foreign trade law, which contains provision on the, yeah, let's say, administration process and also the authorization process. And then, of course, the legal consequences in case of breach of the dual use provisions. And that's also important. In case you apply for this authorization, you also, of course, need to name the end user and provide an end user declaration, end user certificate, because this is, of course, relevant for the authorization, also for the decision whether the authorization is granted or not. So I think in that regard, it's similar to the Australian system. And also, of course, in case of catch-all items, which are not listed, but which can also be dual used, this is also of relevance for the authorization. Next slide, please. Yeah, then when it comes to sanctions, I would explain it based on the Russia sanctions, which is another EU regulation which was introduced in 2014, the number 833, which is the basis for all items related EU Russia sanctions, which was now amended by various amending regulations as part of the various sanctions packages that have been introduced since end of February. And when it comes to dual use items, this sanctions regulation is based on the regular systems, so based on the regular dual use regulation of the EU, and contains some specific provisions for that regard. So when it comes to the export of dual use items, they have been prohibited since 2014 completely for the military sector, so for military end users. And now there's a general prohibition for the export of dual use items. And this is irrespective of you have a military end use or not. So normally, under the normal dual use provisions, it is subject to an authorization requirement. And now in the case of Russia, you have a general prohibition for the export of dual use items. There are some grandfathering rules, so you can apply, or you could apply for authorizations for contracts that have been concluded before 26th of February. But now for new contracts, there's a general prohibition. And there are some exemptions still for, let's say, for humanitarian purposes and pharmaceuticals and so on. But in general, there's now a complete prohibition for the export of dual use items. And also in that case, this Annex 1 of the dual use regulation is applicable in order to determine what is a dual use item or not. And in addition to that, there are some additional lists of items whose export is also now prohibited. There's Annex 7, which contains a list of so-called advanced technology. So in particular, electronics, computers, telecommunication, information security, and lasers. And there, the basic idea is that the EU wants to cut off the export of advanced technology that is required for, let's say, military end users, like wafers and something like that. And this list is about 63 pages. So a lot of items, and therefore also has a big practical relevance at the moment. And also, as Vera and David mentioned, there's an export ban on luxury items, which, for instance, covers car with a value of more than 50,000 euros, and also additional items, also like wine and champagne or something, which is important for, was important for, in particular for the Moscow society and so on. But their value threshold is 300 euros per item. So, for instance, for the bottle of wine, so it's quite high, and therefore a lot of wine can still be exported to Russia. And that's of course also still the basic rule, because we have a lot of requests from clients asking, is it still possible to do any business with Russia at all? And therefore it's a clear answer is yes, unless the item is not listed, and unless the contract partner, of course, is not listed and it's not a designated person, and you are not affected by any of the sanctions, then you are still in a position to do business with Russia. Of course, this is not only a pure question of law, and a lot of companies cease their Russia business on a voluntary basis. But apart from that, from a legal point of view, in general, it is still possible to do export business with Russia, whereby, of course, now a lot of products, and of course also companies, business partners in Russia are covered by the sanctions. So there's, of course, a significant effect of those sanctions. And as a lot of German companies in particular, but also other European companies are involved there in Russia, yeah, we had, of course, a lot of requests in recent months and weeks, and there's still companies who need to make decisions there, which is, of course, not that easy, also with a view to the impacts in Russia and the circumstances you need to consider there on the ground. So, but yeah, to come back to general system, the Russia sanctions are to an important extent are also based on the general dual use regime of the EU. I think that's it with my slides, Vera. Or do I have another one? Okay. Yeah, as I said in the beginning, there are in fact some exemptions and derogations from the sanctions, some grandfathering rules in particular, which were or are important for a lot of companies, in particular for, let's say, the equipment and machine building industry. There we have some clients who have large projects there in Russia, and in that case, these grandfathering rules can be applicable if the contract has been concluded before 26th of February. But that, of course, in any event needs a case-by-case assessment and also a individual authorization. And at the moment, there are, of course, a lot of applications for those authorizations. And yeah, therefore we are in a regular contact with the authority here in Germany, because to discuss these cases. And yeah, there will be, like, for instance, companies who have delivery contracts with Ukraine and also Russia, and also with the areas of Luhansk and Donetsk. And so there are a lot of cases going on, and we have applied for a number of authorizations. And of course, everybody hopes that there will be peace soon in Russia, and then from that end, the practical relevance of the sanctions maybe will hopefully end one day. But at the moment, of course, it's a big issue for a lot of companies here in Germany.
Yeah. Thank you very much, Michael. Can imagine. And last but certainly not least, let's hear from Molly about the US. Please, Molly, go ahead.
Thanks, Vera. And I apologize for my voice, everyone. I have finally succumbed to COVID. So I'm quarantining with my family. So if you hear cartoons in the background, that's my children. Plus, I think you saw one of them pass by here. So like Michael said, the practical answer to people who say, can we still sell to Russia, is yes, so long as your items are not listed on our commerce control list, which is our Wassenaar arrangement dual use list. And so long as they're not listed in one of our non-dual use lists, which covers industrial equipment, oil and gas equipment, and luxury items. And so long as there aren't denied parties or restricted parties involved, which for the United States extends to even non-dual use or ER99 items when military end users are involved. So the answer is yes, you can still technically export to Russia without a license in many cases, but there's a lot of due diligence required to get to that point. And that includes Belarus. Belarus and Russia are subject to the same restrictions in the United States. There are full embargoes, and I've kind of laid out the timeline here, but in the interest of time, I think I can just summarize it all for you. There are full embargoes on the export of items that are subject to our export regulations and imports from Donetsk, Luhansk, and Crimea. The Crimea embargo has been in place since 2014 though. And then there have been a lot of restricted parties added to not only our SDN list, which is our specially designated nationals list, which is maintained by our Department of Treasury, which we talked about last time, but there are also a lot of restricted parties that our Department of Commerce has added to our entity list. And generally there is a restriction on providing anything that is subject to our export regulations to entities on the entity list. One of the biggest changes that came with the Russia-Belarus export controls, in addition to the requirement for a license for all dual use items now, is an expansion of what is subject to our export regulations. So I think if we can skip to the next slide, I can briefly talk about that, because that is a big change. And our export regulations are very broad in their application. I think they're much broader than the EU and the UK, in that they apply to anything manufactured or developed in the United States, but also anything that was shipped from the United States. And it follows the items through their exports. So if I export an item to Michael in the EU, and then he exports it to David in Australia, that's considered a re-export, and it is still subject to our export regulations. So it's a very broad jurisdiction that often surprises foreign companies. In addition to this broad restriction, we have what are known as the de minimis rule and the foreign direct product rule. And the foreign direct product rule is what has been expanded with respect to Russia and Belarus, so I'll talk about that in a minute. The de minimis rule has been in play for a very long time, and it has tripped up a lot of companies wanting to do business with Iran or Cuba or Syria that could otherwise do business. Basically, what the de minimis rule means is that anything manufactured or developed outside the United States, so this includes commodities and technology and software, that contains more than a certain level of US content. And it does require that content to be controlled content, which is a whole analysis. Hold on, Maeve. Yes, you can turn on that. Go get Deirdre's help. Sorry, guys. That's my 3-year-old. So the de minimis rule requires more than a certain level of controlled content, which can be all US content for Iran, Syria, Cuba, and North Korea, and Crimea and Donetsk and Luhansk, or it can be controlled content which requires a license for all other countries. So the de minimis threshold is 10% for our embargoed countries and regions and 25% for everywhere else. Now, the foreign direct product rule is a little known rule that very rarely applied to manufacturing outside the United States until a couple years ago when the Department of Commerce expanded it for Huawei exports. And what they've done is they've expanded it even further for Russia and Belarus exports so that anything manufactured outside the United States based on certain US technology, and this includes all technology on our dual use list, or in plants containing certain US equipment, and this includes equipment based on certain US technology or actual US equipment. Anything manufactured based on US technology or in US plants can be subject to our export controls depending on its classification and its destination now. So that is a very broad expansion. And basically what it has done is it has caused a lot of US companies to look at their, Chinese factories basically and see whether anything they manufacture there would be restricted for export to Russia or Belarus. Next slide, please. So the violation penalties for our export administration regulations are the same as our Department of Treasury penalties. They can be up to $330,000 per violation, which can be multiple violations in one transaction. And they can also include other administrative penalties like denial of export privileges from the United States, listing on one of our bad guy lists, including the entity list, and debarment from government contracting. There are also criminal penalties if there was knowledge or willfulness involved in a transaction. So this is very important to go to the next slide and talk about the due diligence that's required if you are going to sell into Russia. So due diligence on the entities with whom you're transacting business. We talked about this a lot in our last webinar, but it's still very important because even if there's not a license required on the export control side from the Department of Commerce, there may be a license required from the Department of Treasury because the person with whom you're transacting is a restricted party. Properly classifying your items to understand whether they are on the dual use list, whether they're not on the dual use list, but are covered by one of our restrictive lists regarding industrial machinery, luxury items, or oil and gas equipment is very, very important. And then getting end user forms, because as I discussed, any initial export is covered by our regulations, as well as all future exports, re-exports, in-country transfers, etc. So those are kind of some of the best practices that we recommend if someone is still thinking about doing business in Russia. There's export control licenses from our Department of Commerce. There are sanctions licenses from our Department of Treasury, and all military exports were effectively prohibited last year without a license. So that is from a US perspective. Hopefully I did that quickly and people can still ask questions.
Thank you very much, Molly. And this issue about the extraterritorial application of the US legislation should be kept in mind by the companies in general, right?
And Vera, I do think that we could probably sort of cover some of the questions that were sent to me with that sort of final question that we had. One, where can we find the US dual use list, Molly, just quickly?
Yeah, so that's on the Department of Commerce website. So what you're going to search is Commerce Control List, CCL list, and it's laid out in categories 0 through 9. There's an index for easy searching on the Department of Commerce website. So start at the index, search your product, and if it comes up with certain repetitive categories, like for industrial equipment, category 2, for like vaccines and medical stuff, could be category 1. For electronics, you're looking at category 3, 4, 5.
Thanks, Molly. And Vera, I know the one other topic that we sort of wanted to cover was a broad, more general sort of what are the other considerations. And we did have some questions regarding contractual considerations that need to be considered when it comes to export controls and how agreements and contracts made pre-crisis would be impacted. So David, do you want to go ahead and quickly take that one?
Thank you, Hannah.
I can. There's one aspect. We're talking a lot about very specifics and are you impacted and can you do this? When I spoke earlier, I talked about context. I talked about where your goods would lie, goods or services would lie, as far as being munitions, as being dual use or non-dual use. I talked about the end user and end use. And again, context is the issue. And I say that because while we've been on this webinar, something popped up in my email to tell me that the UK has just put in sanctions of Russian sanctions on accounting services, consultancy services, and public relations services. Now, if you want to know if you can do business with Russia, think of the context. All of these things are targeted. Why would the UK stop these three services? Because economic sanctions are financial, so they don't want to export their UK accountancy services to help the Russians figure out their financial situation. They don't want them to figure it out. Consultancy services. Think of risk management. That's what consultants do. They don't want them having that service. Public relations. How do I spin this? How do I come out of this looking like I'm not a bad guy? No, we want you looking like a bad guy is what the UK is saying. That's the point. So we're not going to export those services to you. Context is a very important way to, that's your first assessment of, is this going to be a problem? Can I do business or can't I? You have to look at the context and you have to look at the national interest in either allowing it or preventing it. That's where it comes in. And that just popped up on my screen while Michael was talking. So yeah, I wanted to share that with you. But the question was about contracts and how being listed on an export control list or being prohibited from exporting your contracts that existed pre this situation, what happens now? And there are a lot of implications that are perhaps not anticipated. And again, some of that goes to what I spoke about earlier, where sanctions and export controls, their functions are somewhat interchangeable. They're melding and becoming closer to one another in how they're being applied in this situation. One common contractual obligation, and it happens in structured finance, in complex contracting, in project, large project financing, there'll almost always invariably be a clause that says that down the chain of providing this this project, of delivering this project, there won't be sanctions violations. And that can not only impact the contracting itself, but the finance and the insurance for it as well. And what happens when you get somebody gets put on Molly's entity list? She mentioned that, and I love that one. Be careful, you're going to get put on the entity list. And this happens. The entity list seems a lot like sanctions to me. but it's not, it's export controls. So how does that impact that clause? Wait a minute, they're on the list, but what list are they on? It's an export controls list, it's not a sanctions list. So what does that mean? Everybody involved has to figure that out and answer that question. And it depends on how your contract is drafted. And if it's broadly drafted, you might be stuck. If it's specific and it says sanctions, technically that's not sanctions, but you're there for the same reason. It depends on how your contracts are drafted. So you have to go through and see where you sit and where your clients are going to be exposed or not exposed, depending on what regime suddenly they find themselves a part of, or touching or interacting with, or just unlucky enough to become involved in a project that quite often has nothing to do with the underlying situation that's controlled. And I hope that was clear, because it's getting late here, and I'm not always clear at midnight, but I try my best. So Vera, are there any other?
Yeah, no, thank you very much. And if Hannah, do you think we have a last question for Michael? Very quickly.
Do we have one for him?
Yeah, just a very quickly for Michael. What do you think
Sure.
about the due to the proximity of the EU market with the Russian and Belarus markets? What do you think about these export controls? Are they the future of these export controls? Are they going to be stronger and stay longer in force? What do you think about that?
Yeah, I mean, at the moment, it appears that it will be, at least for a significant period of time, because you all know the war is ongoing and there's no peace settlement in sight. So unfortunately, I think we will have to deal with it for probably months or years. And I mean, a lot of companies are now ceasing their Russia business, so probably the practical relevance will go down. But at the moment, it's really a big issue. And yeah, as I said in the beginning, of course, we all hope that there will be peace sometime, and then there will be a normal relationship, or a kind of normal relationship. But I think the political level has made clear that for the next time, sanctions will be probably tightened, as David mentioned, for the UK, and the EU has similar plans. You know, there's an oil embargo in the pipeline, which will be probably be concluded now, and it will be imposed in steps, because it's not possible to do it as a one shot. It's because the consequences are, of course, very significant, and particularly for some states like Hungary and Slovakia, which are very much dependent on Russian energy. Germany as well, but when it comes to oil, not to that extent. And therefore, there's a discussion going on, but I think it's clear there will be some kind of oil embargo. Yeah, and therefore, of course, this will remain a big topic for the next months, probably, and maybe also years. Yeah.